Holden is present for today with her attorney, Mr. Bo Seaton. Ms. Holden is appearing in front of you under True Bills Indictment 2022 GS 45172 and GS 45139. She's pleading guilty to one count of theft of a controlled substance and one count of neglect of a vulnerable adult. The state does have a recommendation, and your honors are ready to hear it, and a factual summary.
Place your left hand on the Bible, raise your right. Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
I do.
Okay.
Okay, Ms. Holden, I'm Judge Curtis. Ma'am, I understand that you're here today to plead guilty to neglect of a vulnerable adult. And Mr. Matthews, that carries what?
0 to 5 years, your honor.
And then also, theft of a controlled substance first offense.
0 to 5 years.
And is that your understanding as well?
Yes.
And you've discussed your decision to enter this plea with Mr. Seaton?
Yes, ma'am.
And are you satisfied with what your lawyer's done for you?
Yes, ma'am.
You're not under the influence today of any drugs or alcohol?
No, ma'am.
Has anyone promised you anything to try to get you to plead guilty?
No.
Has anybody forced you, threatened you, coerced you in any way?
No.
You're waiving some constitutional rights today when you enter. Knowing all those rights, are you pleading guilty or not guilty? Are you pleading guilty or not guilty? Okay, Mr. Matthews, if I can hear the facts, sir.
Your Honor, in February of 2022, Agent Sarah Chapman with DPEC was contacted by another agent from DPEC who heard from King Street Nursing Facility from Mr. Logan McGill, who is the Human Resources Director there, contacted DPEC and said they had an issue with a patient, Ms. who complained about not receiving her hydrocodone medication. So Agent Chapman was brought in to attempt to reconcile the medication administration report. And it was discovered when reconciling the logs for the narcotics distribution for the nursing home for January of 2022 and February of 2022 that approximately 30 Percocet or hydrocodone tablets were missing from the medication, from what should have been distributed. There was a 30 tablet discrepancy. Ms. Holden was the nurse on shift, or licensed practical nurse at that time. She agreed to meet with Agent Chapman for an interview. She waived her Miranda rights and she gave a statement. And when was asked by Agent Chapman if she had diverted any hydrocodone medication, she admitted that she had in fact began doing so in January of 2022. The offenses she's pleading here today correspond with the date January 7th. There was another date, February 9th. The state is dismissing those charges. So the factual basis for the theft of the controlled substance is Ms. Holden's admission that she did in fact take the Percocet or hydrocodone tablets. The neglect of a vulnerable adult charge is the factual basis for that. Is was complaining to other nursing staff about not having received her medication and needed the medication for pain management. So the state's theory, had this case gone to trial, would be that Ms. was under pain because she did not in fact receive her medication. So that's the factual basis for the neglect of a vulnerable adult. Ms. Holden doesn't have a criminal history. There was another administrative issue with past. We can't confirm that it had to do with something like this. Would not share with me the details of that incident, but she was not arrested for it. The state is recommending a probationary sentence because Ms. Holden doesn't have a criminal history, and the state believes as a condition of that probation it would be beneficial for Ms. Holden to undergo drug court treatment with Judge Land, and I believe that's really what drug court is designed to do. Ms. Holden was very forthcoming meeting with the DHEC agent. She admitted that she had a substance abuse problem and it did cause problems with her personal life, and I think Ms. Holden would really benefit from some drug court treatment.
Ms. Holden, are those facts true?
Yes, ma'am.
Can't you find that there's a sufficient factual basis for me to accept the plea? And I find that you're entering the plea today freely and voluntarily, understanding your rights and with the advice of a very competent lawyer. You do have 10 days from today's date if you wanted to appeal the conviction. Mr. Seaton, I'm glad to hear from you, sir.
Thank you, Judge. As the Attorney General stated,
She was very cooperative from the very beginning. She has no prior history. We are also asking that you allow her to enter into the drug court program. There are probably more of my clients that I would not suggest to them that they enter than they do, because it is a difficult program. But I think it is designed, as the Attorney General said, for people like Ms. Holden. She also started with an injury and became addicted to pain pills as a result of it. And I think you have to have that sort of self-awareness to be successful. I think if you're just out there without that sort of insight, I don't think you're ever going to be successful. And I think that's step number one, and I think she possesses that ability, Judge. And for that reason, when the Attorney General offered us that chance, we jumped at it. I do think she'll be successful at the program. I think she's interested and anxious to do it. And for those reasons, we would ask that you accept that recommendation.
I'm fine to go along with the recommendation. Drug court's a great program. It's rigorous, but they have a lot of resources to help. And of course, the goal is to have you be successful. So if you look at it that way, that they want you to succeed. They're not looking to trip you up. Anytime that I can give her credit for.
Mr. Seaton, I don't know how much time she did, jail or
2 days.
Okay, what I'm doing is 5 years suspended to probation for 5 years. These are concurrent sentences, same sentence on both, giving 2 days of credit, requirements of probation are, of course, completing drug court, random drug and alcohol testing. I am told that if I give less than 5 years of probation, that with compliance credits, you can't get through drug court timely before probation ends. That's what I understand. I have indicated on here that you can terminate your probation upon successful completion of drug court. I think if you just go straight through and do everything you're supposed to do, it takes about a year. So a little incentive for you there to be able to get through a little faster. All right, good luck to you, ma'am.
Thanks so much, Your Honor.
Thank you, Your Honor.
Let's see this.
This is Kristi News TY. I'm Tony Conyers. Is there any newsworthy events in Williamsburg County? We will get them to you as soon as possible. If not, you can follow us on Kristi News TY Facebook. You can follow us on YouTube, and you can follow us on our website.
In federal court, Trevor Raekwon Seward, 25, of Andrews, South Carolina, was convicted following a multi-day jury trial of all 5 counts charged: murder of a federal employee in the course of her duties, use of a firearm in furtherance of a crime of violence, robbery, possession of a firearm by a convicted felon, and conspiracy to possess with intent to distribute and to distribute marijuana. Evidence presented by the government at trial in the case established that on September 23, 2019, Seward was anticipating the delivery of 2 pounds of marijuana that had been shipped from California through the United States Postal Service. Rather than deliver the package to Seward's resident in Andrews, South Carolina, mail carrier Irene Pressley placed a form in Seward's mailbox stating that the authorized recipient would need to come to the post office to claim the package. After Seward confronted Pressley minutes later and failed to get the marijuana package, he returned home. Seward left home shortly thereafter, armed with an AK-15 in search of Pressley. Approximately 1 hour after she had left the form in Seward's mailbox, Pressley was driving down Senate Road in Andrews, South Carolina, when Seward fired approximately 20 rounds off from his RK-15 into the back of Presley's vehicle, striking her multiple times. Seward then got into Presley's vehicle and drove approximately 3 miles away, where he left Presley and her vehicle in a ditch on an access road to a hunt club. While on the access road, Seward removed mail from Presley's vehicle and searched through packages for the package intended for his residence or any other items of value. The package of marijuana that had been shipped to Seward's residence was later found on Senate Road, where Presley had been shot by Seward. United States District Judge Donald C. Coggins presided over the trial and will sentence Seward after receiving and reviewing a pre-sentence report that will be prepared by the United States Probation Office. Seward faces a mandatory penalty of life imprisonment for the murder of Presley. Seward also faces up to life imprisonment for the use of firearm in furtherance of Presley's murder, up to 20 years imprisonment for the robbery of Presley, up to 10 years for illegal possession of a firearm, and up to 5 years imprisonment for the marijuana conspiracy conviction. The prosecution of violent crime is a priority for our office, and that is especially true when the victim of that violence is a federal employee murdered for doing her job, said U.S. Attorney Ada F. Burris. We are grateful for the work done by our federal and local partners, particularly the United States Postal Inspection Service and the Williamsburg County Sheriff's Office, in their effort to bring justice for such a senseless act of violence. This conviction demonstrates our commitment to ensure that all USPS employees can work and serve the public without having to endure an atmosphere of fear and intimidation. The U.S. Postal Inspection Service will utilize all of our resources and work in collaboration with our law enforcement partners to identify and hold individuals responsible that threaten a safe work environment for all our employees, said Tommy D. Cook. Postal Inspection is charge of the Atlanta Division. Our thoughts and prayers continue to go out to the Pressley family, and we are thankful for the assistance from those who helped to ensure the defendant was held accountable for the senseless act of violence against Irene Pressley. We are committed to bringing anyone who commits crime or violence in Williamsburg County to justice, said Williamsburg County Sheriff Stephen R. Gardner. We are thankful for the jury's decision in this case to hold Trevor Seward responsible for his murder of Irene Pressley, a murder committed because she refused to deliver 2 pounds of marijuana to him. The case was investigated by agents of the United States Postal Inspection Service, the Williamsburg County Sheriff's Office, the Federal Bureau of Investigation, the South Carolina State Law Enforcement Division, and the Charleston County Sheriff's Office. Assistant United States Attorney Nick Bianchi, Catherine Flynn, and Ellie E. Klein are prosecuting the case.
Christian News TY would like the family to know we love you and God bless you. Please share this video.